lives lost and all those who are still there to save. We're going to get there. I can come up with all these ideas about the laws we can change to make it easier. You're convincing your neighbors and people this is necessary. That's the power of this movement. That's the power of America.
Lifetime arm ban. The Firearms Policy Coalition, or FPC, announced its filing of a legal brief in the case of Williams versus Garland. This lawsuit, supported by FPC, challenges the federal government's lifetime ban on the exercise of Second Amendment rights due to a misdemeanor conviction for a nonviolent crime. The case centers around Edward Williams, who, following a 2005 trial, was convicted of driving under the influence in Pennsylvania. Despite this being his second DUI offense, his previous one having been expunged, the 2005 conviction was classified as a first-degree misdemeanor. This classification carries a maximum sentence of up to 5 years imprisonment. However, Williams did not serve prison time. Instead, he was subjected to 90 days of house arrest, a $1,500 fine, court costs, and mandatory completion of any recommended drug and alcohol treatment. FPC President Brandon Combs denounced the federal government's lifetime ban on Williams' Second Amendment rights as both immoral and unconstitutional. Combs emphasized that this ban has no historical basis, reaffirming FPC's commitment to dismantling arm control laws that infringe upon individual rights. FPC's brief in the case relies heavily on the precedent set by the U.S. Supreme Court in the decision of New York State Rifle and Pistol Association versus Bruin. This landmark ruling clarified that arm regulations are valid only if the government can demonstrate their consistency with the nation's historical tradition of arm regulation. According to Cody J. Wisniewski, president of the FPC Action Foundation and an attorney representing FPC, the government has failed to meet this burden in Williams' case. Wisniewski contends that the ban constitutes a clear violation of Williams' constitutional right to keep and bear arms. Edward Williams is represented by attorney Joshua Prince, while FPC's representation is provided by Cody Wisniewski. FPC continues to fight for what they see as unjust and unconstitutional restrictions on arm ownership, leveraging legal actions and public policy advocacy to advance their mission. FPC is a 501c4 nonprofit membership organization dedicated to defending constitutional rights and promoting maximal human liberty. They work to restore individual freedoms and ensure that arm control laws do not infringe upon the Second Amendment. FPC encourages individuals who wish to support their cause to join the FPC Grassroots Army or make tax-deductible donations to the FPC Action Foundation. The FPC Action Foundation is a 501c3 nonprofit organization aims to achieve maximal human liberty through various initiatives including charitable legal action, public policy, education, and research programs. Both organizations use their platforms to inform, educate, and mobilize supporters to defend constitutional rights and individual liberties. The outcome of Williams versus Garland could have significant implications for the interpretation of Second Amendment rights, especially concerning individuals with nonviolent misdemeanor convictions. The case brings into question the balance between public safety measures and constitutional rights, highlighting the ongoing debate over arm control and individual freedoms in the U.S. By challenging the federal government's lifetime ban in this context, FPC aims to set a legal precedent that limits the scope of arm regulations, ensuring that they adhere to historical traditions and respect individual rights. This case underscores the broader mission of FPC and FPCAF to protect and restore the freedoms enshrined in the U.S. Constitution, advocating for minimal restrictions on the right to keep and bear arms. FPC continues to engage its community and the public through various channels, encouraging active participation and support in their efforts to challenge and change laws they consider to be unconstitutional. FPC Action Foundation petitions. The FPC Action Foundation has submitted a significant brief to the U.S. Supreme Court, urging it to grant certiorari in the case of Morin versus Liver. This case contests Massachusetts' lifetime ban on arm purchases for individuals convicted of nonviolent misdemeanors. The brief, also supported by the FPC, is available at fpclaw.org. The case centers on Alfred Morin, Ph.D., a Massachusetts resident and former license to carry permit holder. In 2004, Dr. Morin traveled to Washington, D.C. with a handgun, unaware of the city's strict arm regulations. Upon seeing a sign prohibiting arms at the American Museum of Modern History, he approached a guard to inquire about checking his arm. This led to his arrest and subsequent charges for carrying a pistol without a license, possession of an unregistered arm, and unlawful possession of ammunition. The Superior Court of the District of Columbia sentenced him to 60 days of imprisonment on each count, 3 months of supervised probation, and 20 hours of community service. Massachusetts law currently allows individuals convicted of nonviolent misdemeanors to obtain a license to possess a handgun at home after 5 years. However, these individuals are permanently barred from purchasing handguns, with the only legal means of acquisition being through inheritance. Dr. Morin is petitioning the U.S. Supreme Court to review a decision by the U.S. Court of Appeals for the First Circuit that upheld this ban. The brief argues that both English and American traditions support arm prohibitions for dangerous individuals, those posing a threat to the government or exhibiting violent tendencies. It clarifies that there is no historical precedent for disarming peaceable citizens or limiting the Second Amendment to so-called virtuous citizens. Historically, nonviolent criminals without a propensity for violence were not barred from keeping arms. Some laws even explicitly permitted them to do so. Interpreting the Second Amendment in light of history and tradition, as established in the landmark case of District of Columbia v. Heller, the people entitled to keep and bear arms include peaceable individuals like Dr. Morin. Joseph Greenlee, Director of Constitutional Studies at FPC Action Foundation and author of the brief, emphasizes the widespread issue of individuals being denied Second Amendment rights due to nonviolent misdemeanor convictions. Greenlee points out that history supports the full Second Amendment rights for peaceable persons, yet many are still denied these rights based on nonviolent offenses. He expresses hope that the court will grant certiorari and restore Dr. Morin's rights. The brief also references Greenlee's extensive scholarship on the subject, particularly an article published in the Wyoming Law Review in 2020, titled "The Historical Justification for Prohibiting Dangerous Persons from Possessing Arms." This article provides a comprehensive historical analysis supporting the position that only individuals deemed dangerous should be prohibited from possessing arms. Felon in possession arm ban. The federal appeals court are currently divided on whether the federal ban on individuals convicted of a felony possessing arms, known as the felon in possession prohibition, violates the Second Amendment. A federal appeals court judge predicts that the Supreme Court will address the constitutionality of Section 922G1 or provide clearer guidance on whether felons are protected by the Second Amendment. The Supreme Court has largely remained silent about the meaning of the Second Amendment, with its 2008 decision in District of Columbia v. Heller adopting an individual right interpretation. However, Heller left unanswered questions about the scope of the constitutional right, leading to uncertainty among lower courts regarding whether the Second Amendment right extends beyond the home to public places. In the 2022 case, New York State Rifle and Pistol Association v. Bruin, the Supreme Court clarified that the Second Amendment right is not restricted to the home, and that it applies to at least some public places where confrontation may occur and self-defense may be needed. The court announced a test requiring courts to view Second Amendment challenges through the dual lenses of text and history, stating that the government must demonstrate that the regulation is consistent with the nation's historical tradition of arm regulation. The Bruin court clarified whether the Second Amendment right recognized in Heller extends beyond the home and applied the test to assess whether modern arms regulations are consistent with the Second Amendment's text and historical understanding. Lower courts have been asked to address the interplay between Heller and Bruin, including whether certain arms restrictions thought to have been permissible under Heller are constitutionally invalid post-Bruin. The federal law prohibits individuals convicted of a crime punishable by imprisonment for a term exceeding 1 year from possessing arms. The Third and Ninth Circuits have held that the felon in possession ban is unconstitutional, as applied to specific parties. In the Third Circuit case, Range v. Attorney General, Brian Range argued that the prohibition prevented him from purchasing a rifle for deer hunting and self-defense purposes, violating the Second Amendment. The court ruled that the plain text of the Second Amendment implicates the felon in possession ban, which would preclude Range from possessing a rifle to defend himself in the home. In the Ninth Circuit case, United States v. Duarte, Stephen Duarte was convicted of being a felon in possession of an arm in violation of Section 922G1. The court agreed that the government's proposed historical analogs for the lifetime felon in possession ban were inadequate, as early laws were aimed at disarming certain disloyal individuals, insurrectionists, and non-citizens. The majority held that the historic response to the underlying crime was controlled, and some of Duarte's offenses either were non-existent or would have been a misdemeanor at the time of the founding. The Supreme Court has rejected constitutional challenges to Section 922G1, either as applied to particular parties or categorically. The 7th, 8th, 10th, and 11th Circuits have rejected these challenges, citing Heller's language that the ruling does not alter existing prohibitions on arms possession by felons. The 8th Circuit upheld the felon in possession ban as constitutional, relying on the Supreme Court's language in Heller and concurring opinions from Bruin. The 10th Circuit upheld the categorical ban on felons possessing arms, explaining that we have no basis to draw constitutional distinctions based on the type of felony involved. The 11th Circuit also remained bound to its post-Heller, pre-Bruin circuit precedent. The Supreme Court is currently reviewing a case, United States v. Rahimi, which invalidated a federal law prohibiting the possession of arms by persons subject to certain domestic violence restraining orders. The U.S. has requested the court to hold the petition in range pending a ruling in Rahimi, and may assess how the Rahimi decision informs the meaning of the Second Amendment and the methodology applicable to constitutional challenges to arms laws. That's all for this video, folks. See you next time.